You know how fast? Do you want me to tell you how fast you're going? You're 117. 117. Why are you going so fast? Do me a favor, pull up into the Congo River parking lot there.
On December 7th, 2025, a Pinellas County officer stopped a white Dodge Challenger clocked at 117 miles per hour on US 19. What followed was a textbook application of Florida's newest criminal traffic statute. 5 months earlier, Governor DeSantis signed House Bill 351 into law, creating Florida Statute Section 316.1922, dangerous excessive speeding. Effective July 1, 2025, this statute fundamentally changed how Florida treats extreme speed. The statute triggers in 2 ways. First, exceeding the posted speed limit by 50 miles per hour or more. No additional proof of dangerous conduct required. Second, traveling at 100 miles per hour or more in a manner that threatens public safety. At 117 miles per hour on a road posted between 45 and 55, this driver triggered both prongs simultaneously, roughly 62 to 72 miles per hour over the limit and well above the 100 mile per hour threshold. A first conviction carries up to 30 days in jail and a $500 fine. A second conviction within 5 years escalates to 90 days, a $1,000 fine, and mandatory license revocation between 180 days and 1 year. This is no longer a civil infraction. It is a criminal misdemeanor.
Five eight one. Copy, 10 minutes. South by 19, Seville. Seville, Florida tag, Charlie Yankee, Charlie Adam Robert Ocean, CYCAR. I was gonna be on white Dodge Challenger.
Incident assigned.
Need a license?
Do you want to just stay here?
Let me get your license first, okay? So I'm off to your H, by the way. I'm off to your H, by the way. The reason I'm stopping you. You know how fast you're going there on 18? What's that? You know how fast? Do you want me to tell you how fast you're going? You're 117. 117. Why are you going so fast? Do me a favor, pull up into the Congo River parking lot there. Can I get one more? Can I get one more? I'll be in the Congo River parking lot. You have the registration and insurance of the vehicle? Okay. You still live in Newport Richard there?
Yeah.
Okay. Alright, just take time. I'll be right back with you. How about I talk to you? You got shoes? Yes, nothing. Relax. Can you take this off? How old are you? Yeah. Oh,
If I drop my phone.
you won't get all that stuff, okay? We'll walk over here, okay? The reason why you're handcuffed right now is because, like I told you, you're doing 117.
Yeah, I literally never go that fast. I have 0 speeding tickets.
At 117 miles an hour. Do
It's
you know
a
that
fast car.
Right. Do you know they just passed a new law, right?
No, I'm not aware.
Okay. So anything over 100 miles an hour or 50 miles above the speed limit, it's a misdemeanor. Okay? You understand that, right?
So what does that mean?
You're being arrested for your speed limit. Okay? Alright? It's not a joke, okay? 117, you're passing that car. You're in the far left lane. It's better on that car at 117 miles an hour.
Sorry.
Just because you're having fun.
I understand.
Okay?
Wait, why is he being arrested?
We'll get everything squared away, okay?
Oh, did they leave the car on?
Well, should I have the keys in there?
I don't know.
Is it whose car is
I
it?
think it is.
It's your car, right?
Yeah, it's my car.
Okay.
Should be in there.
Alright, is there anything on you? Because I'm gonna have a female officer come search you.
Okay.
There's nothing on you.
No, I would prefer
Alright,
to have
so
my
who is that to
phone,
you?
That's my husband.
That's your husband. Alright, did he tell you to slow down or?
Yeah.
He did it?
I mean,
It's not,
yeah,
it's not,
It's fast.
okay? There's not a place to do it, right? If you want to go that fast, there's a racetrack for that kind of stuff. Okay?
Yeah, we know.
Because what you're doing is it's racing too, okay? It's considered racing. You're an exhibition of a speed, all right?
Sorry, I really wasn't aware. I literally never go fast.
Okay.
And then happened.
All right, well, just hang tight.
Right.
we
I
have
have a question.
What
Why
do
is he getting arrested?
Because everybody in the car for racing, it goes to jail, okay? I'm going to go talk to him here in a second. But that's how it is. It doesn't matter. People can they be sitting on the side of the street watching racing. They can go to jail, okay?
But are we like actually going to jail, or is it like
Yes.
bond out type of situation?
No, you're going to jail, okay? Just hang tight. I'll come back and talk to you in a second.
Officer Tybacota Police Department. I'm here just to conduct your search, okay? Do you mind stepping out for me? Have you faced the vehicle and take a step away from the car? Widen your stance for me. Okay. Anything on your person? Okay. I give everybody this discretion, okay, so don't take it personally. Anything on you at all whatsoever. Okay, any introduction of contraband into the jail is an additional felony. I'll be happy to charge you with it if they find anything, so that's why we like to give everybody that heads up, okay? All right, let's see.
I'm just going to read you something real quick. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer, have him or present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questions of your race. You can sign anytime. Exercise these rights. Not answering the questions or make any statements. Do you understand each of these rights I've explained? Is it a verbal yes or no?
Yes.
Okay. So, like I explained to him, because you guys got dogs at home, and he's got a license, he's a registered, I'm gonna let him take the car home, okay? So you guys can, so he can take care of the dog, okay? That's not the place to do it, okay? Because if somebody pulled out in front of you or something like that, at that speed, you can really hurt somebody really bad, okay? I don't think you want that under conscious, right? Right? No. It's you, okay.
No, I don't.
Okay. You seem like a good person. I think you just made a bad choice today. Okay. Like I said, they just passed this new law. We're not playing around with the speeds anymore, okay? Like I said, anything over 100 miles an hour, or anything 50 miles above the posted speed limit, okay? You're looking at jail time, okay? So, I gotta do some paperwork. You gotta get a citation for me. I'm not going to do the racing statute. I'm just going to do the dangerous speed statute. Okay? The 1 over 100 miles per hour, 50 miles above the posted speed limit. If I decided to do the racing charge, I could take both of you to jail. Okay? I'm not doing that, right? Where were you guys coming from? Your house? Where were you guys headed to?
We're trying to buy something off Facebook Marketplace, so we're heading towards his house in Florida.
Down in Largo?
But the officer faced a critical charging decision. Florida Statute Section 316.191, racing on highways and exhibition of speed also applied. The officer explicitly told the driver her speed constituted exhibition of speed under this statute. Section 316.191 is a first-degree misdemeanor up to 1 year in jail, fines between $500 and $2,000, and a mandatory 1-year license revocation. More importantly, under this statute, passengers who knowingly ride in the vehicle also face criminal charges. The officer chose the less severe statute. Quote, "I'm not going to do the racing statute, I'm just going to do the dangerous speed statute." This single decision spared the driver's husband a passenger from arrest and criminal prosecution. This is prosecutorial discretion exercised at the patrol level, and it was well calibrated. The driver had no prior record. There was no competitive racing element. The speed, while extreme, appeared to be a momentary lapse, not a deliberate exhibition. Charging under 316.191 would have been legally defensible, but disproportionate. The arrest procedure itself provides a useful case study. The officer handcuffed the driver, then delivered a full Miranda advisement, the right to remain silent, the right to an attorney, and confirmation that the driver understood. Under Berkemer v. McCarty, decided by the Supreme Court in 1984, Miranda protections apply to all custodial interrogations regardless of offense severity. This includes misdemeanor traffic arrests. The officer's decision to Mirandize was legally sound. However, Miranda is only required when two conditions are met: custody and interrogation. A routine traffic stop, standing alone, does not trigger Miranda. The moment handcuffs went on and questioning continued, the obligation arose. The officer met it. The search incident to arrest raises a Fourth Amendment consideration. The officer called a female officer, Officer Taylor, to conduct the pat-down of the female driver. This aligns with department best practices, though it is not constitutionally required. It is, however, a strong liability shield. Officer Taylor also delivered the standard contraband advisory: any introduction of prohibited items into the jail constitutes an additional felony. This warning is both practical and strategic. It eliminates an ignorance defense and gives the arrestee a final opportunity to disclose. One procedural note worth examining: the officer allowed the husband to drive the vehicle home rather than impounding it. Under Section 316.191, the officer could have impounded the vehicle for up to 30 days. Under 316.1922, no such authority exists. This further validates the charging decision. By selecting the dangerous, excessive speeding statute, the officer preserved the family's access to their vehicle and avoided compounding financial hardship on top of criminal consequences. The broader enforcement context matters. In July 2025 alone, the first month of the new law, 71 drivers were charged statewide, 49 for exceeding 100 miles per hour, 22 for exceeding the speed limit by 50 or more. 7 arrests occurred on the very first day. Florida Highway Patrol made enforcement a stated priority.
You're going to get a ticket today, okay? Hopefully this will be your last one, alright? Alright? You have any questions for me? You have anything?
Yeah, you want us to relocate her to target over here?
No, I'll just pull it. Pull that
Over here?
Yeah, just whatever.
Alright.
Wait a sec. Because you're going to get a citation, I'm going to put your ID back in here, okay?
And have the phone number in there?
Yes, with the phone number.
Right. And do I get that when I get there?
Yeah, just let them know you have a phone number, they should give it to you. Or they might let you write it down, I don't know how it works when I get down there. But the ID is going to be in this envelope too, okay?
Right. Thank you.
You have any other questions for it?
You got it all switched up. Pre-staging did not do well.
Yeah.
Right.
Now for the grades. The officer receives a B+. The stop was legally justified, tactically sound, and professionally executed. Miranda was properly administered. The charging decision demonstrated measured discretion. Points were deducted for imprecise legal explanation. The officer stated that anything over 100 automatically results in jail. Under the statute, the 100 mile per hour threshold also requires dangerous conduct, though at 117. This distinction is academic. The officer also loosely characterized the speed as racing, which carries a specific statutory definition not clearly met here. The driver receives a B. Cooperative throughout, no resistance, no confrontation, immediate compliance with all instructions. She confirmed understanding of her Miranda rights and expressed genuine remorse. However, driving 117 miles per hour to a Facebook Marketplace purchase is indefensible from a public safety standpoint. At that speed, the vehicle covers 172 feet per second. Reaction time is nearly eliminated. One unexpected variable, a lane change, a pedestrian, a tire failure, and the outcome is catastrophic. The department receives an A-. Officer training was evident in every procedural step: same gender search, Miranda compliance, contraband advisory, and appropriate use of discretion. The rapid availability of a female officer suggests adequate staffing. 3 takeaways from this encounter. First, for drivers. Florida's superspeeder law is real. It is being enforced aggressively, and it carries criminal consequences, including jail time. Ignorance of this law, as this driver demonstrated, is not a defense. Second, for officers, charging discretion matters. This officer's decision to apply the less severe statute was legally sound, proportionate, and protected an innocent passenger from unnecessary criminal exposure. That is good policing. Third, for everyone, if arrested, invoke your Fifth Amendment right to remain silent and request an attorney. Cooperate physically, but understand that anything said after Miranda can and will be used in court. Silence is not guilt. Silence is a constitutional right. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.